The ranch had been in my family longer than any HOA within 50 miles. Wide pasture, old fencing, a dirt road that predated asphalt, and a deed recorded so far back it still referenced landmarks that no longer existed. When I finally moved back to manage it full-time, I expected work, fences to mend, cattle to rotate, taxes to sort out. What I didn't expect was a certified letter taped to my gate claiming the land now fell under expanded HOA jurisdiction. At first, I laughed. HOAs were suburban creatures. This was open ranch land. No shared driveways, no manicured lawns, no community clubhouse, just grass, livestock, and silence. The letter said the association had updated its boundaries and that my ranch was now subject to their rules, assessments, and oversight. It demanded immediate compliance and access for inspection. No signatures. Just a printed board name and a phone number. I ignored it. 2 days later, an SUV I didn't recognize rolled up the dirt road and stopped short of my cattle guard. A woman stepped out wearing sunglasses and a blazer that didn't belong anywhere near livestock. She introduced herself as the HOA president and said she was there to verify occupancy. I told her she was trespassing and pointed to the posted signs. She smiled tightly and replied, "This land is under our authority now." That was the moment I realized this wasn't a misunderstanding. It was a grab. Over the next week, the letters escalated. Notices of violation. Claims that my fencing didn't meet community aesthetic standards. A demand for back dues calculated from a date before I even owned the ranch. When I called the number, I was told calmly that if I didn't comply, enforcement would follow. I asked what enforcement meant. The answer was short: law enforcement involvement. I started documenting everything. Every letter was scanned. Every sign was photographed. I pulled my deed, the survey, the county plats, and the easement records. Nothing, absolutely nothing, showed any HOA authority anywhere near my property. The boundary lines were clear, the access roads private, the land zoned agricultural with 0 covenants attached. This ranch wasn't just outside their control, it was legally untouchable. That didn't stop them. One morning, as I was checking water lines, 2 sheriff's deputies pulled onto the property. The HOA president stood behind them, arms folded, already acting victorious. She told the deputies I was occupying HOA land without authorization and refusing to cooperate with association governance. She claimed the meeting they were headed to would clear everything up. The deputies asked for documentation. She handed them a glossy packet full of maps that conveniently blurred boundary lines and highlighted areas labeled community managed space. I handed over my deed and survey. The deputies exchanged a look but said they couldn't resolve property disputes on the spot. Instead, they advised a formal meeting with the HOA board and county mediation present. The HOA president smiled again. "Good," she said. "We'll settle this properly." That was her mistake. Because once it became a meeting, it became public record. And once it became public record, facts mattered more than confidence. I agreed to attend, not because I was worried, but because I wanted everything on paper. Every claim, every lie, every attempt to assert control over land they had no legal claim to. As the deputies left, one of them quietly told me, "Bring everything you've got." I planned to. The days leading up to the meeting were a crash course in how far an HOA will push when it thinks confidence can replace legality. I received emails reminding me that non-attendance may be interpreted as admission. Another warned that continued defiance could result in fines, liens, and forced compliance. They spoke as if ownership were optional and authority was something they could vote into existence. I didn't respond. I prepared. I contacted the county recorder's office and requested certified copies of every document related to my parcel, the original deed, subsequent transfers, zoning confirmations, and survey maps. I pulled aerial imagery from 3 different decades, all showing the same uninterrupted ranch boundary. I even found meeting minutes from the HOA's founding that explicitly excluded agricultural parcels beyond a certain road. That road still existed. My ranch was well past it. Meanwhile, the HOA president made the rounds. Neighbors from nearby subdivisions stopped by to warn me that the board was telling people they were reclaiming unused land for the community. One said the president claimed the ranch was abandoned and under dispute, despite cattle grazing in plain view. Another mentioned they were discussing converting part of it into shared green space. None of them had ever set foot on the property, but they spoke with absolute certainty. The meeting was scheduled at the HOA clubhouse, a polished building with glass walls and a stone sign out front that read Community Governance Center. I arrived early, carrying a hard case full of documents and a digital recorder. The room filled quickly. Board members sat behind a long table, flanked by the HOA's attorney. The president sat in the center, smiling like the outcome was already decided. She opened by stating that the ranch fell within newly clarified boundaries and that I had refused multiple good-faith attempts at compliance. She described my refusal as hostile and suggested it posed a risk to the community. When she finished, she gestured toward me and asked if I had anything to say. I asked one question. Can you produce a recorded document showing HOA authority over my deeded parcel? There was a pause. The attorney began talking about interpretive maps and community development intent. I repeated the question. The president interrupted, saying they would present their materials shortly. I nodded and waited. They projected a color-coded map onto the screen, zoomed out just enough to blur details. My ranch appeared inside a shaded zone labeled HOA Influence Area. I stood up and asked permission to present. They agreed. I placed my first document under the projector, the original recorded deed, stamped and signed, with a legal description that clearly excluded any HOA covenants. Next came the county survey, showing unmistakable boundary lines. Then zoning records stating no HOA jurisdiction. I overlaid their map with the official county plat. The shaded area stopped half a mile short of my fence line. The room shifted. Board members leaned in. The attorney stopped taking notes. The president's smile thinned. I continued, calmly explaining each document, each record, each inconsistency in their claim. I read aloud from their own founding minutes, highlighting the section that excluded agricultural land beyond the access road. Several people in the audience murmured when they realized what was happening. Finally, I addressed the police involvement. I explained that law enforcement had been called under false pretenses and that continued claims of ownership could constitute harassment and attempted fraud. I didn't threaten. I stated facts. The attorney requested a recess. When they returned, the tone had changed. The HOA president no longer spoke first. The attorney did. He said there appeared to be a misinterpretation of boundary authority and suggested the matter be reviewed further before any enforcement actions continued. I nodded. Good, I said, because I'm not done yet. The meeting wasn't going the way they planned. When the meeting resumed, the confidence that had carried the HOA board through the opening statements was gone. Chairs shifted. Papers were shuffled. The president avoided eye contact as the attorney cleared his throat and suggested a collaborative clarification process. That phrase alone told me everything. They weren't clarifying anything. They were retreating. I took that moment to ask for the floor again. This time, I didn't lead with documents. I led with process. I asked when the board had voted to expand its boundaries, where that vote was recorded, and which county office had approved it. The attorney tried to deflect, saying the expansion was administrative. I reminded him that boundary changes require recorded amendments, landowner consent, and county filing, none of which had happened. The room went quiet. A board member finally spoke up, asking how the ranch could be included if it had never been part of the association. Another asked why dues had been calculated without ownership authority. Each question widened the crack. The president attempted to regain control, claiming the board had acted in the community's best interest. That phrase drew a few sharp looks from the audience. Best interest didn't mean lawful. I then addressed the police call. I asked the deputies, who had agreed to attend as observers, to confirm whether they had been told the land was HOA-controlled. One deputy nodded and said yes. I followed by asking whether any documentation had been provided at the time. The deputy shook his head. The implication hung in the air. Calling law enforcement without proof wasn't enforcement, it was escalation. The attorney intervened again, stating that no further police involvement would occur while the matter was under review. I thanked him and moved on to my final point: trespass. I presented photos of HOA representatives on my property, timestamps included, and copies of the posted signage. I explained that any future entry without permission would be treated as trespass and documented accordingly. That was when the president finally spoke, her voice tighter than before. She accused me of being uncooperative and resistant to community harmony. I responded calmly that harmony doesn't override ownership and governance doesn't apply where authority doesn't exist. A few people in the audience nodded. The attorney asked if I would consider mediation. I said I would consider closure. I wasn't there to negotiate land I already owned. I was there to stop false claims. The difference mattered. The board called for another recess. This time, it lasted longer. When they returned, the decision was delivered carefully. The HOA would temporarily suspend all claims and enforcement actions regarding my ranch pending a full legal review. They would also issue a written notice retracting prior violation letters and acknowledging the boundary discrepancy. I asked for that in writing with a timeline. The attorney agreed. As the meeting adjourned, people approached me quietly. A few thanked me. One neighbor admitted they'd always suspected the board pushed limits, but had never seen anyone push back with evidence. The deputies shook my hand and said they appreciated the clarity. The HOA president didn't say a word. Outside, the evening air felt lighter. Not because the fight was over, but because the balance had shifted. They no longer held the narrative. The facts were now part of the record. Any future claim would have to pass through documents, law, and public scrutiny. On the drive back to the ranch, I replayed the meeting in my head. Every moment confirmed the same truth. Authority unchallenged grows reckless. But authority confronted with evidence collapses quickly. They had claimed my ranch. They had called the cops. And now, in front of witnesses and paperwork, their claim had begun to unravel. The written notice arrived 3 days later by certified mail. The tone was carefully neutral, stripped of the confidence that had filled the earlier letters. It stated that the HOA was reassessing jurisdictional boundaries and that all enforcement actions against my property were suspended indefinitely. No apology. No admission. Just a quiet retreat wrapped in legal language. That wasn't enough. Suspension meant they still believed they might come back. I wanted finality. I forwarded the notice to my attorney and asked one question: what would it take to make this permanent? The answer was simple but uncomfortable for the HOA: public correction. If they had made public claims, sent police, and issued violations, then the retraction needed to be just as visible. Silence would only invite repetition later. So I requested one more meeting. This time, the board hesitated. Emails took longer to answer. The attorney asked if written clarification would suffice. I said no. I wanted the correction entered into the minutes, read aloud, and recorded. Reluctantly, they agreed. The second meeting was sparsely attended. No audience. No deputies. Just the board, the attorney, and me. The president looked exhausted. The attorney opened by reading a prepared statement acknowledging that the ranch lay entirely outside HOA jurisdiction, that previous communications had been issued in error, and that no future claims would be made against the property. I asked for one addition. I wanted the record to state that the prior police call had been based on incorrect information provided by the HOA, and that law enforcement had no authority or expectation to intervene on behalf of the association regarding my land. The attorney paused. The president objected. I waited. After a brief discussion behind closed doors, they returned and agreed to the language. It was read into the minutes. Recorded. Final. I thanked them and stood to leave. That's when the president spoke again. She said, quietly this time, that the board had only been trying to protect community interests and that things had gotten out of hand. I told her that power often does when it isn't checked. I wasn't angry. I was done. Back at the ranch, I updated my records. I added the meeting minutes, the retraction letter, and a formal notice of no trespass addressed to the HOA as an entity. Copies were sent to the county and the sheriff's office for reference. If my land ever came up again, the answer would already be on file. The impact spread further than I expected. Over the next week, 2 different landowners contacted me. One said the HOA had previously hinted that his back acreage might be absorbed someday. Another said they'd been fined for a road the association didn't maintain. Both asked how I handled it. I told them the truth: documents, patience, and refusing to be intimidated. The HOA stopped expanding, at least publicly. Their board elections suddenly became contentious. People ask questions. Authority, once exposed, doesn't regain its old shape easily. For me, the ranch returned to quiet. No more letters. No surprise visits. No assumptions of control. Just land, work, and the steady rhythm that had existed long before any association meetings or glossy maps. One evening, I walked the fence line as the sun dropped low. The boundary markers stood exactly where they always had.
Solid.
Unmoved. The land hadn't changed.
Only the story around it had.
They had tried to claim what wasn't theirs. They had used the police to apply pressure. And in the end, they had been forced on record to admit they never had a claim at all. That was the real victory. Months passed, and the ranch settled back into its natural silence, but the effects of that meeting continued to ripple outward. The HOA never contacted me again. Not a letter, not an email, not even a rumor carried by neighbors. Their confidence had been replaced with caution, and that alone told me the record mattered more than any argument ever could. What surprised me most was how often people reached out afterward. Landowners from nearby areas, some technically inside HOAs, some just outside, asked how I had stopped the board so completely. Many assumed it required lawsuits or endless legal battles. When I told them it came down to documentation, process, and refusing to be rushed, they seemed almost disappointed. The truth wasn't dramatic. It was disciplined. The HOA, on the other hand, changed dramatically. Board turnover happened within the year. The president resigned quietly, citing personal reasons. New members ran on promises of transparency and restraint. Meeting minutes became more detailed. Boundary discussions disappeared entirely from agendas. Once an association is forced to correct itself publicly, it rarely forgets the embarrassment. For my part, I made permanent changes. I upgraded signage along access points, clearly stating private agricultural land and no association jurisdiction. I filed updated plats with the county, making the boundaries unmistakable even to someone skimming a map. I also established a written policy. Any future claims, inquiries, or inspections required written proof of authority before discussion. No exceptions. The sheriff's office appreciated that. One deputy later told me my documentation became a reference point when other HOA-related calls came in. It gave them clarity before stepping onto land that didn't belong to an association. That, to me, was a quiet win. It meant fewer people would face the same intimidation tactics. Looking back, the most dangerous moment hadn't been the police visit or the meeting itself. It was the assumption behind it all that most people would comply simply because a board said so. That hesitation, that instinct to avoid conflict, is what allows authority without jurisdiction to spread. The HOA had counted on it. They just picked the wrong property. The ranch never needed defending in a physical sense. It needed defending on paper. Ownership isn't proven by fences or confidence. It's proven by records, law, and the willingness to stand still when someone tries to push you off your ground. Once I understood that, everything else became straightforward. Sometimes, late in the evening, I still think about how close it came to becoming a precedent. If I hadn't challenged them, the HOA would have logged my compliance as proof of authority. From there, it would have been easier to pressure the next landowner and the next. That's how boundaries shrink, quietly, incrementally, and with paperwork most people never read. Instead, the record now shows the opposite. It shows an association overstepping, being challenged, and backing down under scrutiny. That record will outlive any board member or policy shift. It's permanent in a way confidence never is. The ranch remains what it always was: independent, working land, governed by county law and common sense. No meetings. No dues. No glossy maps pretending to redraw reality. Just open space, clear boundaries, and the understanding that ownership carries responsibility, not submission. They claimed my ranch. They called the cops. And in the end, the only thing that changed was their belief that they could ever do it again.